Peter Elgar has been arraigned on 2 charges. To the first, a charge of attempting to obtain money by deception, he has pleaded guilty. To the second, he's pleaded not guilty. The full charge against the defendant is a long and involved one, as set out in the Criminal Damage Act of 1971. But in simplest terms, one word will suffice: arson. The prosecution has just called its first witness, Station Officer Roy Pettit of Fulchester Fire Brigade.
Received a shout to a fire at number 17 Manning Street.
You received a shout, you say?
Yes, my lord, excuse me. I should say we received a call from Command Control.
Thank you.
To a fire at number 17 Manning Street, Fulchester. The pump escape and the pump, with myself in charge, were ordered. We arrived at the address at 20:59 hours, at which time half the ground floor of number 17 was well alight.
Yes, this was a shop known as Elgar and Stroud Antique and Fine Furniture Dealers.
That's correct.
Now, you got there in 4 minutes. That's very good going, isn't it?
Yes. There was fortunately very little traffic at that time of evening. I was first on the scene, and I rang the bells and banged on both front doors.
Both front doors?
And one to the shop and one to the flats above. There was no one in the shop, so we had to effect an entry.
Yes, how did you effect an entry?
By forcing both the locks on the front door.
The door being locked from the outside?
Oh, yes, my lord. Shops are always locked from the outside.
Unless, of course, the proprietor lives on the premises.
Well, that's true.
Yes, I'm grateful to your lordship for mentioning this. The fact that the front door was securely locked from the outside is significant. Please carry on, Mr. Pettit.
I ordered 2 hose-reel jets to be laid out and a message to be sent by radio. Make pumps 4, persons reported.
Persons reported?
In my opinion, it was not 100% sure that everyone was out of the building.
So what did you do about that?
I sent a couple of BA men up to ventilate and search.
Yes, BA men.
And members of the crew with breathing apparatus.
Yes.
There was a lot of smoke going up the staircase. Now, it was at this time that a lady's head appeared at one of the windows on the 2nd floor. She must have had her front door open because the smoke going upstairs was coming out of her window. She was in a panic. We shouted at her not to jump, that we'd have a ladder up to her in no time, but there was too much noise. Maybe she didn't hear us. She jumped. One of my crew tried to break her fall, and I think he did, slightly, but she still hit the pavement and was seriously injured.
Yes. Am I right in saying that this lady was the only person to suffer injury as a result of the fire?
That's correct.
But had it not been for the prompt arrival and action of the fire brigade, the steps leading up to the flats above could have caught fire and all the tenants' lives would have been in danger.
My lord, my learned friend is leading the witness and also asking him to conjecture.
Yes, that is so, Mr. Lotterby, but the witness is qualified to give an expert opinion, and I don't see why we shouldn't hear it. Mr. Pettit, would you say that the fire in the shop premises might have spread to the flats above and so endangered the safety of the tenants?
It might have, my lord. We got it under control just in time to prevent it spreading upstairs, but the tenants did have ample warning to get out of the building.
Then their lives were not endangered.
Well,
now, I ask you to think very carefully before you answer that question, because it relates directly to that part of the charge against the defendant which reads, being reckless as to whether the lives of the tenants of 17A Manning Street would be thereby endangered.
I would say that, as it happened, their lives were not in immediate danger. But if the fire had spread more quickly, as it might have done, or if the alarm had been given a bit later, say 10 or 15 minutes later, then some lives definitely would have been in danger.
I see. Thank you, Mr. Parsons.
Thank you, my lord. Now, to go back to the fire in the shop itself, what happened there?
The whole place was alight. Wooden furniture burning like logs. The fire was most intense at the back of the shop. It was 15 minutes to get through into that back room.
The back room, is that part of the shop as well?
Yes, and it took another half hour to get the flames in there under control.
And was it furniture burning in there as well?
Well, it was difficult to tell what it was that was burning. But I subsequently discovered that that was where the fire had originated.
Well, how did you learn that?
Well, investigations after the fire showed that it had been burning for a longer period there because the structural damage was more severe due to the extent of charring on bulk timbers and the amount of spoiled plaster in that area.
Spoiled plaster?
Spoiled, my lord, meaning flaking off under extreme heat.
Spoiled? Oh, yes, I once had that word in a crossword puzzle.
Yes. Anything else?
Anything else?
I mean, did you notice anything else in the back room?
There's a 5-gallon drum in the corner of the room. It was scorched and discoloured and slightly buckled from the heat, but otherwise intact.
Now, what did it contain?
Well, it was empty. But it had contained paraffin.
Well, how did you know it had contained paraffin?
You could smell it. There was a strong smell of paraffin that side of the room, and the can itself smelled of it.
I see. And anything else about the can?
Oh, yes, the tap. The little tap at the bottom was in a diagonal position.
Meaning what?
Well, meaning that it was neither fully closed nor fully open.
Yes, but what effect would that have if the can had been full of paraffin when it was put there with the tap in that position?
There would have been a leakage.
Yes.
Paraffin would be dripping from the tap for some considerable time.
Yes. Apart from the can, was there also a paraffin heater in the room?
No?
Well, what about the front part of the shop? Was there a paraffin heater there?
No.
Was there a paraffin heater anywhere on the premises?
No, there were electric radiators.
Electric radiators? Well, what was the 5-gallon can of paraffin for?
I've no idea.
But would you say whoever set fire to the shop used this paraffin in order...
Yes, Mr. Lotterby. Mr. Parsons, you know perfectly well that it is for the jury to decide whether or not someone set fire to the shop.
I'm sorry, my lord. Perhaps I may rephrase the question.
Yes, please do so.
Mr. Pettit, would you say that however the fire was started, the paraffin in that part of the room was the reason that the conflagration spread so rapidly?
Oh, yes. Without the paraffin, there would have been a much longer period of smouldering before there was enough fire to spread. There's a fair amount of smoke with this preliminary stage of smouldering, so that often a fire is detected before it's really caught hold.
But with paraffin?
Instant flames.
Yes. Now, was there any indication that this fire had been started with the use of paraffin?
Well, with respect, it's not for me to give opinion on the origin of a fire. I mean, that's not my function. That's for the fire prevention officer.
Yes, who in this case was Divisional Officer Norman Cook.
Yes.
Yes, my lord, perhaps this is a good opportunity to introduce under Section 9 of the Criminal Justice Act 1967, Division Officer Cook's report.
Yes. You don't object, Mr. Lotterby?
No, my lord.
I will not read the whole report, my lord. I'll just read the final sentence. Because of a shortage of evidence to indicate precisely how the fire would have arisen, accidental or otherwise, and because of the unexplained presence of paraffin, the fire can only be described as of doubtful origin. Now, do you agree with this statement by the fire prevention officer?
Yes, I do.
Of doubtful origin, meaning suspicious.
Well, not suspicious exactly.
Mr. Pettit, now surely there are only two ways that a fire can be started, either accidentally or deliberately.
Yes, my lord.
So that of doubtful origin must mean that there is an element of suspicion that the fire was caused deliberately. Well, isn't that so?
I suppose so, yes.
Thank you. No further questions, my lord.
Now, Mr. Pettit, I appreciate your reluctance to express an opinion as to how the fire was started. If one thinks of the presence of that paraffin in the back room of the shop, it would be only too easy for you to have said to yourself, so that's how someone got the fire started. But that was not your conclusion, was it?
Not definitely, no.
No, and neither was it the definite conclusion of the fire prevention officer whose written report we just heard read. Now, a few moments ago, you stated that a fire often has a preliminary period of smouldering. Is that right?
Yes.
Mm-hmm. Now, for how long a period can a fire sometimes smoulder before it breaks out in flames?
Some considerable time.
Could you be more specific than that? Could the smouldering period last for, say, an hour?
Longer than that.
How long?
Several hours. In the right circumstances.
What circumstances?
Well, it would depend on the substance involved. Some substances can smoulder for a very long time.
Such as?
Carpets, rugs,
Anything else?
cushions,
Yes.
leaves, especially if the leaves are slightly damp. The same applies to hay and straw.
Any other household items?
Bedding, blankets and mattresses.
Blankets, you said?
Yes.
Was there any trace of blankets in that room?
No. Any blankets there would have been totally consumed by the fire.
It was a large square room, wasn't it? About 20 foot square, would you say?
Yes, about that.
Do you have any idea what it was used for?
Well, not at the time, but I subsequently learned it was used for storing furniture which was not on display in the front part of the shop.
Yes, for storing furniture and also for packing items ready for transportation. Now, do you happen to know how valuable antiques are packed ready for transport?
No, I don't.
Well, they are invariably wrapped in old blankets, as being the best method of avoiding scratching. So this being the case, there might have been a number of blankets in that room. So would you say that the fire could have been smouldering amongst them?
This witness is being asked a question based on a supposition put forward solely by my learned friend.
Yes, that is so, Mr. Parsons, but I have no doubt that Mr. Lotterby intends to produce later evidence that there were blankets in the room.
I do indeed, my lord.
Members of the jury will bear in mind that so far there has been no evidence produced that there were any blankets there.
Thank you, my lord. Now, Mr. Pettit, assuming for one moment that there was a pile of blankets in the back room, would you say that the fire could have been smouldering amongst them for some considerable time before it actually ignited?
Only if the blankets are in a different part of the room to the paraffin.
Yes, precisely. Now, that was the point I was coming to. And if they were, and if the fire did start among the blankets, then its origin would have had nothing whatever to do with the paraffin, would it?
Not in those circumstances.
Could have been smouldering for as much as several hours, and only when it finally reached contact with the part of the room where the paraffin was, would it have actually burst into flames. Am I right?
What is it you're asking me?
I'm asking you if, as I shall later prove, there was a pile of blankets in a different part of the room to the paraffin, then the fire could have started several hours before the fire brigade was called. In fact, it could have started before shop closing time, before 6 o'clock.
Well, it's possible, but
Thank you, that's all. No further questions, my lord.
Did you wish to add something to your answer, Mr. Penn?
Well, only that it is possible, my lord, but I would doubt it.
Why would you doubt it?
Because if the fire had been smouldering that long, there would have been smoke. Quite a lot of smoke, which might have caught the attention of some passer-by.
Yes, I see. Do you have any re-examination, Mr. Parsons? Thank you, officer. You may go.
I call Terry Green.
Terry Green, please.
What is your occupation, Miss Green?
I'm a claims investigator for an insurance company.
Employed by...
Sovereign Life and General Assurance Company, Headingley, Leeds.
did the defendant, Peter John Elgar, have a policy with that firm?
He had two policies, a comprehensive motor vehicle policy for his van and a fire and accidental policy for his shop premises.
And did he make a claim on the latter policy following a fire at the premises of Elgar and Stroud on September 22nd last?
Yes, he did.
And were you appointed by your firm to investigate that claim?
I was.
And during the course of your investigation, Miss Green, did you meet the defendant?
Yes, I travelled from Leeds to Fulchester on September the 28th, which was the day after our claims department had received the completed form from Mr. Elgar. I made some inquiries in Fulchester and then arranged to meet Mr. Elgar.
Yes, where did the meeting take place? At the shop?
No, at his home, a cottage at Haley Hill, just outside Fulchester. Mr. Elgar invited me to tea on Sunday the 30th of September. He seemed very tense and nervous, but this was perhaps understandable. I asked him how he believed the fire had started.
Yes. Did he give you an answer?
He said he thought it was most likely some electrical fault and that he'd more than once asked the landlords to have the place rewired, but they had not done so. I pointed out to him that in the report by the fire prevention officer, no electrical fault had been found. He said by the time the report was made, the place was so gutted out it would be impossible to tell. I then asked him to let me have further details about each item listed on the claim form as having been lost in the fire.
Did he comply?
Yes, as far as he could.
Well, what sort of details were you asking for?
Signed receipts showing how and when he'd acquired each antique and how much he'd paid for them.
And was he able to give you these?
Very few. He said his papers had all been destroyed in the fire. The only receipts he was able to give me were those he had on him in his wallet at the time of the fire. As it happened, those included some of the most valuable antiques, ones which amounted to more than half the total claim.
Yes. Well, did you ask him why those particular receipts happened to be in his wallet at the time of the fire?
There was no need to. The 5 items had been purchased only 2 days before the fire.
So only 2 days before the fire, the defendant acquired 5 valuable antiques, which amounted to more than half the total insurance claim.
Yes.
Well, do you now produce the defendant's insurance claim form? Exhibit 1, my lord.
Yes.
As you will see, my lord, on the list there are 5 items with ticks against them. These represent the items the defendant bought 2 days before the fire, and they add up to a total of £5,100 out of a total claim of £9,600. Now, Miss Green, did the defendant say anything else you considered important?
I didn't notice at the time, but later in my hotel room when I was listening to a playback of the tape, I noticed
One moment, please. A playback of what?
Of the tape recording, my lord, I made of the conversation.
You made a tape recording of your conversation with the defendant?
Yes. And I noticed that when
Was the defendant aware that this conversation was being recorded?
No, my lord.
You mean you had a tape recorder concealed about your person?
In my handbag, with a microphone here, hidden in a brooch.
Yes, I see. Mr. Parsons, are you intending to put in this tape recording as evidence?
No, my lord. I would point out, however, my learned friend does have a transcript. The only reason the tape has been mentioned at all is because it brought to the attention of the witness to something that she hadn't considered significant at that time.
Yes. Yes, I see. Please continue, Miss Green.
My lord, with respect, if my learned friend is not going to produce that
No,
recording...
Mr. Lotterby, I don't think the tape recording need be produced if the witness has an independent recollection of what the defendant said. Yes, Miss Green, carry on.
I noticed that when I commented on the high price of these 5 particular antiques, 2 of them being valued at well over £1,000 each, Mr. Elgar's reply was, they are actually worth more than that.
Yes, the significance being the use of the present tense. I mean, it was more than a week since they were supposed to have been destroyed in a fire, and he said they are worth more than that.
Yes.
Yes. Now, what did you do when you noticed this?
I drove down to Salisbury to the antique shop where the 5 items had been purchased.
With what object in mind?
To get a detailed description of those antiques from a neutral party and, if possible, to get photographs of them.
Yes. Did you succeed?
Oh, dear, dear me, where are we now? I have a fear that we're going to be faced with hearsay evidence.
Yes, you are, my lord, but only with evidence which the defence does not dispute.
Oh, very well, then let's get on.
Thank you, my lord. Now, did you succeed in getting the description you wanted?
Yes. The Salisbury dealer had photos of 2 of them in a catalogue of an auction sale in April 1973 when he had purchased them himself.
Yes. Do you recall what those 2 antiques were?
Yes, a Pembroke table and a Queen Anne bureau. I had copies of the photos made, enlargements, and sent them to some people I know who have connections in the antique business.
Yes. Now, why did you do that?
Well, just on the off chance that an antique identical to one of those might put in an appearance somewhere.
And did it?
They both did. About 2 months later, in the first week of December, I received a phone call saying that a Pembroke table and a Queen Anne bureau, exactly like those in the photos, had been sold to a visiting American agent by a dealer in Chelsea, London. I went to London and visited the dealer, pretending that I was a customer and that one of the things I was interested in was a Queen Anne bureau. He said...
sorry, what was the dealer's name?
Oh, I'm sorry. Richard Hartley.
Yes, thank you.
Mr. Hartley said how unfortunate he'd sold one only recently. I asked him where he had acquired it, as they're very hard to find. He said he had acquired it privately and did not wish to give the name. However, as a result of having Mr. Elgar followed, it turned out to be...
What exactly did that mean, having Mr. Elgar followed?
I had hired a firm of private detectives in Fulchester to keep watch on his movements.
At whose expense?
The firm's, my lord, Sovereign Life and General Assurances.
I see. Carry on.
On the 10th of December last, Mr. Elgar travelled by train to London where he had a meeting with Mr. Hartley in a restaurant, during which a photo was taken of them.
Yes. My lord, I would draw your attention to a photograph of the defendant in a London restaurant with Mr. Richard Hartley, which is exhibited in the deposition of the private detective.
Yes.
Now, what was your next move, Miss Green?
I returned to Fulchester and went to see Mr. Elgar, this time without an invitation. This was on the 14th of December. I told him I had reason to believe that some of the most valuable antiques listed on his claim form had not been destroyed in the fire and had recently been sold in London. He denied it. I said I believed they'd been sold by a Mr. Hartley. He denied any knowledge of Hartley. I said I believed he'd recently travelled to London to see Mr. Hartley. He denied it. I then showed him the photo.
And what did he say?
Oh, for a long time he didn't say anything. He just stared into space, like in a trance. I then told him I was sending in my report on his claim and that it would contain evidence that he had made false statements with intent to defraud the company of several £1,000s and that I had reason to believe he had set fire to the shop himself.
Yes, and what was his reaction to that?
Oh, nothing for a while. He just sat there, nodding his head slightly. And then when I turned to go, he jumped up and came over and asked me. He said, please, not to send in my report. He would waive all his claim. He wouldn't even claim on the stuff that had really been damaged in the fire. Well, I told him to forget it. The whole claim was null and void any road, and it was a matter for the police. He said it was the first time he'd ever done anything like this. He said that his mother was very old and ill, and it would be the death of her.
And what did you say to that?
Me? I just laughed in his face and said, don't bother to see me out.
Yes. My lord, perhaps I should remind the jury at this stage that the defendant, Peter John Elgar, has pleaded guilty to a charge of attempting to obtain by deception in respect of a fraudulent insurance claim.
Yes.
Thank you, Miss Green. No further questions.
Miss Green, how long have you been an insurance company investigator?
How long? Oh, about 1.5 years.
You enjoy the work?
Yes, it's a very good job.
It's a rather odd profession, isn't it, for an attractive young woman like yourself?
What you mean is that it's the sort of job everyone takes for granted has to be done by a man. I think that's what's odd.
Yes. Yes, in fact, I suppose your sex is an advantage in this sort of work.
Sometimes, yes.
People might speak more freely to you than to a man.
Possibly.
And they might be less likely to suspect what you're up to.
What I'm up to?
Yes, well, I mean things like hiring a private detective to follow someone and take photos of them without their knowledge, carrying a tape recorder concealed in your handbag in order to bug someone's conversation. All the tricks of your trade.
Yes. What about it?
And, of course, in addition to that, as a woman, you have the advantage of feminine intuition, don't you? Do you believe in that?
In feminine intuition?
Yes, you find it helps you in your work.
My lord, I really
Yes,
can't see
Mr. Parsons. Mr. Lotterby, have you any idea where these questions are leading us?
I have, my lord.
Oh, would you like to share your idea with the rest of the court?
I shall endeavour to do so, my lord. Miss Green, you added at the end of your report the following sentence. And I have reason to believe he had set fire to the shop himself.
Yes.
Was it feminine intuition made you say that?
No. No, not just intuition, of course not.
Oh, had you some tangible reason other than those you've already given us?
Well, for one thing, the coincidence. The fantastic coincidence that only 2 days before the fire, he purchased these very valuable antiques, which he included in his claim, although they were not in the shop at the time of the fire. Why weren't they? And here's another thing. That shop was locked from the outside. He was the only person who had the keys. So who could have got in and started the fire? Only him.
Unless it was started by some accidental means. Oh, there is one more thing I wanted to ask you. At your meeting with the defendant, your second and last meeting at his home, was there anyone else present?
Yes.
Yes, you didn't mention that before.
I wasn't asked.
Well, I'm asking you now. Was there anyone else present?
His mother.
Yes. Now, when you told the defendant that you were making a report out to your company that he had made a fraudulent claim and that you had reason to believe he had set fire to the shop himself, what did his mother say? Did she say anything?
Oh, I don't recall. She may have done.
Well, I'm asking you to recall. Did she say anything?
She said something. I didn't take notice. I wasn't there to see her.
Miss Green, didn't the defendant's mother say that her son couldn't possibly have started the fire because he was home with her all evening, that the first he knew of it was when they received a phone call at 9:20?
Yes, well, she would say that, wouldn't she?
Never mind whether she would, Miss Green, did she?
She said something to that effect, yes.
Yes. Thank you, Miss Green.
Do you wish to... Thank you, Miss Green. You may go.
I call Gerald Stroud.
Gerald Stroud, please.
The case of the Queen against Elgar will be resumed tomorrow in the Crown Court. In the Fulchester Crown Court, Peter Elgar has pleaded guilty to a charge of attempting to obtain money by deception and confessed to making false statements in an insurance claim. He now faces further charges of having set fire to his shop premises, thereby damaging the property of his landlords and endangering the lives of the tenants above. The prosecution has just called its third witness, whose name, when it was called, seemed to take the defendant by surprise.
Your name is Gerald Arthur Stroud.
Yes?
And you live at 49 Ainsley Terrace, Cambridge.
Yes.
What is your occupation?
I'm an antique dealer.
Were you formerly in partnership with the accused Peter John Elgar in the premises known as Elgar and Stroud?
I was.
And when did you cease to be a partner in that business?
Nearly a year ago.
Yes, but the shop still goes under that name.
The shop doesn't exist anymore.
Yes, and I mean, at the time of the fire, the shop was still called Elgar and Stroud, even though you had left several months previously.
Yes.
Why was that?
Well, since I left of my own volition to join another firm, not in Fulchester, there seemed no reason to change the name. It carried some value and goodwill, and we both agreed it should be kept.
Yes. Now, would you tell the court as succinctly as possible, please, why the partnership broke up?
Well, for a number of reasons, but I suppose the two main ones were, first, with the cost of living rising so much in recent years and our annual turnover remaining about the same, there just wasn't enough in it for both of us. And also the second thing was we had had our differences in recent years, fundamental differences over business methods and our whole approach to trading in antiques.
Yes, so just under a year ago you resigned your partnership and went to work and live in Cambridge.
Yes.
Now, after you left, did you remain in contact with the defendant?
Oh, yes, we kept in touch. We spoke on the phone from time to time. I come to Fulchester occasionally. I have friends still here.
Yes. Now, Mr. Starr, will you please tell the court when you last saw the defendant?
You mean before the fire?
I'm sorry, I didn't put that question very well. When did you last see the defendant at his shop?
On the 19th of September.
Yes, that would be 3 days before the fire.
Yes.
Now, can you please describe that meeting for us?
Well, I went round there in the afternoon. We had a cup of tea together.
Was he expecting you?
No, I just dropped in. I found him in a very depressed frame of mind. I asked him about his mother, how she was. I knew she'd not been well for some time. He said she was about the same, neither better nor worse. I asked him how business was. He said it had been poor. Even the summer months had been disappointing. I asked him if there was anything else that was bothering him, and he said yes. He said he'd recently had a letter from the landlords, Chester and Hussey. The lease on the shop premises was due to expire at the end of the year. They were offering to renew the lease, but at a considerably higher rent. They said that the rent as fixed in 1966 was now unrealistic.
And what was his reaction to that letter?
Well, he was very upset about it. Angry, too. He said he was going to fight them on it. He said he wasn't going to pay the higher rent. The present rent was high enough. He said he'd already said this on the phone to them since receiving the letter, but they were adamant. If he wanted to renew the lease, he would have to pay the higher rent.
And what did he say to that?
Well, he said, well, then I'm afraid he said, the shop can go up in flames for all I care.
So rather than pay the higher rent demanded by the landlords, he said the shop can go up in flames for all I care.
Yes.
No, it wasn't. That wasn't what I said.
Silence in court.
You know that, Gerald. I didn't say that. Gerald, you know that.
Mr. Lotterby.
I didn't say that. I remember it distinctly.
Mr. Lotterby, if your client cannot remain silent, he is in some danger of being removed from the court. Mr. Elgar, your turn to speak will come, but you must not interrupt. Mr. Parson.
No further questions, my lord. Thank you, Mr. Stroud.
When the defendant said the shop should go up in flames for all I care, what did you take him to mean?
Well, at the time, I didn't attach any importance to it.
You
I
didn't take it
really
seriously.
Of course not.
But now you do take it seriously.
Well, yes.
Why?
Well, I could only think there was nothing else for it but to think that he'd done it.
Find it hot in here, Mr. Stroud?
It's quite warm, yes.
Perhaps it's because you're under such tension.
I'm not under any tension.
No? I would have thought it was rather a difficult thing for you to do, to come here and give evidence on this very serious charge against your former partner and friend.
Oh, yes, of course, there's that sort of tension, yes.
Yes. How long were you in the defendant partners?
14 years.
14 years, a very long time. And you were also good friends?
Yes.
Close friends?
Yes.
Am I right in saying for 12 of these 14 years you lived together?
We shared a large flat, yes.
I wasn't asking about the size of your establishment. I was asking if you lived together.
That's correct.
Mm-hmm. And it wasn't until the defendant's mother became seriously ill 2 years ago that he moved out and went to live with her.
Yes.
About a year after this, your partnership with the defendant broke up.
But that had nothing to do with his moving out to live with his mother.
Oh, I didn't say that it had. No, you've told the court that the partnership broke up because the shop wasn't doing well enough to support you both and because the two of you had disagreement about business methods.
Yes.
Was it an amicable separation, was it?
Yes.
No hard feelings on either side?
No.
Must be rare for a long, close relationship like yours to come to an end with in such a friendly fashion.
That I wouldn't know.
Mr. Stroud, were you subpoenaed?
I'm sorry?
Were you given a summons to appear in this court?
No.
How then do you find yourself here in court as a material witness for the prosecution against your former partner and friend?
Well, the police came to see me, do you see?
Where and when was this?
Well, they came down to Cambridge the first or second week in December. The shop was still partly in my name. I suppose that's why they looked me up.
And what did the police want to see you about?
Well, they say they were investigating the cause of the fire at Elgar and Stroud in Fulchester. There were allegations that Mr. Elgar had made false statements in his insurance claim. They were now trying to decide if there was a case against him for having started the fire.
What specifically did they ask you?
If I had any reason to believe he'd done so.
Mm-hmm. What did you say?
I said no, I had nothing to do with the place anymore. I didn't know anything that might help them. But later, about a week later, the inspector had left his card, you see, and asked if I would get in touch if I thought of anything. Well, after long and very careful thought, I rang him and made an appointment to see him. I told him about going to see Peter at the shop a few days before the fire and how angry he'd been about the letter from the landlord saying they wanted to raise the rent and what he'd said about the shop could go up in flames for all he cared. Well, you have to tell the truth in something like this. You can't hold back. To hold back is to lie, and it would be very wrong to lie about something as serious as this.
And can you be absolutely certain that those were the exact words the defendant used?
Absolutely certain.
Oh, one last question. In all the years you've known him, in what must have been a close and intimate relationship, have you ever known the defendant to commit a destructive act of violence?
Not offhand, no.
Not offhand? Oh, what an extraordinary thing to say. If you'd known he'd committed such an act, you'd remember it instantly. You wouldn't need to reflect on it.
I can't remember him committing such an act.
Thank you. You didn't seem very eager to say so.
Do you...
No examination, my lord.
Thank you. You may go, Mr. Stroud.
That concludes the case for the prosecution, my lord.
Very good.
I call the defendant, Peter John Elgar.
Mr. Elgar?
Live at Briar Cottage, Haley Hill, Fulchester.
Yes.
You will have to speak a little louder than that. Are you not feeling well, Mr. Elgar?
I feel all right, my lord.
A few moments ago, Mr. Elgar, you, before you came to the witness box, you seemed distraught. In fact, you appeared to be weeping. Could you tell the court why?
But it would be very... That would be very difficult.
I must ask you to try. What was it that so upset you?
It was just... I suppose it was the surprise, the shock of realizing that I was being betrayed. I just couldn't believe it. I couldn't believe that such a vicious lie could be told by someone who for so many years had been my partner and my dear friend.
The lie you're referring to being...
That I said the shop could go up in flames for all I cared.
Yes, now, do you remember the conversation in which you were supposed to have made that remark?
Yes, it was after I'd shown him the letter from the landlords offering to renew the lease at a very much higher rent. I said I wasn't going to sign the new lease, and the shop could go to blazes for all I cared.
You said the shop can go to blazes for all I care.
Yes.
Meaning what precisely?
Well, meaning rather than pay the exorbitant rent they were asking, I'd give up having the shop. I'd quit the premises.
You mean find another shop?
No, I was thinking of giving up having a shop altogether. I was considering putting up a sign at my mother's cottage at Haley Hill and running the business from there.
Isn't that rather far from the centre of town?
Yes, but there would be a fair amount of passing motor trade.
The shop can go to blazes for all I care. Now, you were certain that this was the phrase you used and that it could not have been misunderstood by Mr. Stroud to mean that you were contemplating setting fire to your shop.
I'm quite certain that was the phrase I used, and I'm quite certain that Mr. Stroud did not misunderstand me.
Now, Mr. Elgar, would you please tell the court what your movements were on the evening of Saturday, the 22nd of September last?
My movements? Yes. I shut up shop soon after 6.
That was your normal closing time?
Yes, any time between 5:30 and 6, depending on whether there was a customer.
Was there that evening?
Yes, there were two. A young couple who'd been browsing around.
Did they buy anything?
No, but they were interested in one or two pieces, and they said they might come back on Monday after thinking it over the weekend.
But, of course, by Monday the shop was permanently closed.
Yes, it was all boarded up.
So that young couple, they were the last customers at your shop. Did you notice anything about them?
Well, they seemed to know quite a bit about antiques.
Did they, whilst browsing, go into the back room to look at the furniture kept there?
Yes.
Did you accompany them there?
Yes.
Did you happen to notice if either of them were smoking?
Smoking, or I can't... No, if they were, I'm afraid I didn't notice.
Presumably there were ashtrays about the place.
Oh, yes, several ashtrays.
Do you smoke yourself?
No.
So these ashtrays, they would have been for the customer?
Yes.
My lord, I do believe my learned friend is overextending both himself and the indulgence of the court.
Oh, in what way, Mr. Parsons?
One moment we're hearing about two apparently nameless people in the shop that evening before closing time.
Yes.
Then we're asked to consider where either of the two people smoked or not.
Yes.
From there, we go on to the presence of ashtrays for customers. My lord, my learned friend is attempting to put into the minds of the jury the notion that this fire was started by the cigarette from a careless customer.
Yes.
In other words, he's putting up a smoke screen.
Yes, well, I'm sure the jury won't be blinded by the smoke screen, Mr. Parsons, and I'm sure also that they will be aware that no evidence has yet been offered that anyone was smoking in the shop on the night of the fire. Mr. Lotterby, the names of this young couple who, the defendant says, were in the shop just before closing time are not known.
No, my lord.
Any attempt made to trace them?
Oh, yes, indeed, my lord. On two occasions, advertisements were placed in the personal column of the Fulchester News, but with no result.
Well, I see. Yes, well, please continue.
So, when the young couple left, you locked up the shop just after 6, and then?
I went home.
Yes. How did you travel?
In the van.
How long was the journey?
About 20 minutes.
20 minutes. Your mother, was she at home?
Yes. I cooked the supper for us.
You cooked the supper?
Yes, I usually do the cooking, and my mother does the washing up.
I see. Please go on.
Then we watched television.
You watched television for the rest of the evening?
Yes.
Until when?
Well, until we had a phone call. Well, two phone calls, one after the other, saying the shop was on fire.
Now, what time was that?
At 9:20.
Which time you'd been home how long?
Oh, nearly 3 hours.
Yes. And then?
I drove to Manning Street, to the shop. The place was still on fire, though it was under control by then. There were crowds of people and fire engines. That part of the street was cordoned off. For a long while, I couldn't get near the shop. I just stood there amongst the crowd, watching.
And afterwards?
Well, it was nearly midnight before I was allowed into the shop to inspect, to look at what was left of the contents. There was nothing, virtually nothing. It was all gone. Everything that was left was black and charred, still smoking, some of it. Even in the main part of the shop, there wasn't anything left that wasn't charred beyond recognition. Just the odd bit of metal here and there, drawer handles, face of a clock. It was all just debris. It took several days to clear it all out.
Now, Mr. Elgar, the court has heard the evidence given by Station Officer Roy Pettit of the Fulchester Fire Brigade concerning the presence in the back room of the shop of a large can, a 5-gallon drum believed to have contained paraffin. Now, can you tell us anything about that? Did you know it was there?
Yes, I bought it.
When did you buy it?
I'm not sure. About a week before the fire.
About a week before the fire, you bought a can of paraffin and you placed it in the back room of the shop.
Yes.
Why?
Well, it was the end of September, and the weather was beginning to get chilly. And that room's always cold, never gets any sun. Also, it was damp, which is very bad for antique furniture. Now, in the past, I've always had 2 electric radiators in the back room, as in the front part of the shop. They're very expensive to run, and last winter, in order to economize, I intended having the electric radiators only in the main part of the shop and a paraffin heater in the back room.
Had you yet purchased the paraffin heater?
No, but I'd looked at several models, and I wasn't sure which one to buy, or whether I'd need 1 or 2 in such a large room.
What was this room used for?
Well, for storing furniture that wasn't on display.
Did you keep anything else there?
Packing materials,
Such as?
blankets, ropes.
How
so on.
many blankets?
About a dozen.
And were there always blankets in that room?
Yes.
Now, Mr. Elgar, you said it took several days to clear the debris from the premises. Was it then that you got round to making out your insurance claim?
Yes, it was 4 or 5 days after the fire that the insurance claim arrived. But I had already on the Sunday, the morning after the fire, scribbled down a list of, well, while it was still fresh in my mind, every item that I had in the shop, whether a valuable antique or just an ordinary piece of furniture like my desk. Now, it was a long list, several sides of foolscap. When I came to fill in the claim form, there wasn't room, so I typed the list separately to be attached to the form.
You were copying the list you had scribbled down the morning after the fire?
Yes. And when I was about halfway through, I suddenly came on 5 items which shouldn't have been there. There was a rather fine Pembroke table, a William and Mary marquetry chest, a set of 6 Hepplewhite chairs, a Queen Anne bureau, and a Sheraton sideboard.
Now, why shouldn't these items have been there?
Because they weren't in the shop at the time of the fire.
Where were they?
In my van.
Now, why were they in the van?
I hadn't unpacked them yet. I'd only had these articles for about 2 days. I'd been down to Salisbury, and I had to clear a space for them. I'd meant to do it on that Saturday evening before closing, but that young couple were in the shop for nearly an hour.
But why, if they're still in the van, had you included them on the original list you had scribbled down the morning after the fire?
I don't know. It's an extraordinary error. I suppose I just scribbled down quickly every item I had in my possession. And I suppose I was still, well, in a sort of state of shock.
Understandably. So a few days later, when you were typing out the insurance claim, you came across these items on the original list.
Yes. For a long time, I just stared at them. I found myself strangely excited because I realized that those items which should have been in the shop at the time of the fire, which might so easily have been in the shop, were still in my van. And I realized that nobody else in the world knew that they were there.
So, what did you do?
What I did was the most foolish, the most wrong thing I've ever done in my life. I went on typing the list, including those items, and I quickly filled in the claim form, I signed it, I dashed out, and I caught the midday post. And all the time I was saying to myself, I've been paying insurance premiums for years, I've never made a claim. The insurance company's made a lot of money out of me, and a few extra thousand on this claim won't hurt them very much. I know what I did was very, very wrong, and I have bitterly regretted it.
Mr. Elgar, you have already pleaded guilty to that offence. Are you also guilty of having set fire to your shop?
No. No, I am not.
Thank you, Mr. Elgar.
Now, Mr. Elgar, you say that in the morning after the fire you scribbled down a list of all the items in the shop that were either destroyed or damaged, and then several days later you typed up a copy of this list to send with your insurance claim. Is that right?
Yes.
And when you sat down to type out the list for the insurance claim, you added 5 valuable items you knew had not been destroyed. Now, there was no error in this, was there? It was a cold, calculated piece of deception, wasn't it?
Yes, I've admitted that.
Yes, I know. I just wanted the jury to be quite clear on that point. Now, can you tell us exactly where these 5 very valuable pieces were in the interim period between the fire at the shop and you making out your insurance claim?
In my van.
But they were still in the van several days after the fire?
Yes.
Why was that?
There was nowhere else to put them. The shop had been gutted.
Yeah, well, what about your home, the cottage? I mean, wouldn't that have been a more suitable place for 5 valuable antiques rather than the back of a van?
There was no room for them at the cottage.
No room for them? But earlier you told the court you were thinking of putting a sign outside the cottage and selling antiques from there.
Yes, but that would have meant my mother and I clearing all our things out of the large room and various structural alterations.
Yes, but isn't it near the mark, Mr. Elgar, to say that the reason those items remained in your van and had remained in your van ever since your return from Salisbury is because that was the best place to conceal them?
Well, afterwards, yes.
Now, what do you mean by afterwards?
After I'd filled in the insurance claim.
After you had filled in your fraudulent insurance claim, you kept them in the van because that was the best place to hide them.
Yes.
Yes. And that's why you kept them in the van all along, isn't it? You never put them in the shop because you knew exactly what was going to happen.
No.
You knew that the shop was going to catch fire, and you knew... And you knew you were going to add these items to your insurance claim, and that's why they never left your van from the moment you bought them.
No, that's not true.
No? But they did leave your van.
No, I'm saying that's not the way it happened.
Will you please tell the court when those items finally did emerge from concealment in your van? Was it when you drove to London and delivered them to a dealer with instructions for them to be sold privately?
Yes.
Yes. Now, when was that?
You mean the date?
Yes, the date.
The 27th of September, I think.
The 27th. Now, according to my reckoning, that would be a week after you bought them and 5 days after the fire. Is that right?
Yes.
Thank you. Now, tell me, Mr. Elgar, did your mother know about the presence of those antiques in the back of the van?
No.
Well, didn't you tell her you'd been to Salisbury to buy antiques?
Yes, of course I did.
Well, where did you say they were?
I didn't say where they were.
Wasn't your mother interested? I mean, didn't you tell her you had just bought 5 very valuable antiques worth several £1,000s?
I didn't even tell her what they were.
Ah! You didn't even tell her what they were. Well, that's very surprising, considering their value.
Look, my mother has nothing whatever to do with this.
No, I'm quite sure you kept her well out of it. Did your mother know you bought those items 2 days before your shop went up in flames? Did she know they were still sitting out there in the van?
I didn't tell
Did you
my
know
mother...
you were going to add them to your insurance claim? No, because if she had, she would only too easily have guessed that you had set fire to the shop yourself.
No.
No? No?
Yes, yes.
Yes, what?
I did. I set fire to the shop.
My lord,
leave me
might I
alone,
ask for an
please.
adjournment?
Leave
My
me
client has
alone.
been under great strain all last week, and his mother is in hospital and may not be able to appear as a witness.
Yes, yes. I think I will adjourn now.
The case of the Queen against Elgar is in its 3rd and final day. After having pleaded guilty to a charge of attempting to obtain money by deception, he now faces further charges in connection with a fire at his shop premises. Yesterday, under cross-examination by the prosecution, he broke down and admitted that he had set fire to the shop. He was unable to continue giving evidence, and the court adjourned early.
My lord, my client is now sufficiently recovered to resume his testimony.
I'm glad to hear it. And the defendant's mother?
Oh, I'm happy to say she is, after all, going to be well enough to appear as a witness.
Then I take it that there is no question of a change of plea.
No, my lord.
Very well. The defendant may return to the witness box. Mr. Parsons, have you concluded your cross-examination?
No, my lord.
I would remind you, Mr. Elgar, that you are still on oath. And I would remind the jury that everything the defendant said in the witness box yesterday was also on oath. Now it is up to you to attach what importance you think right to certain utterances which were made, possibly hysterically, impulsively, or under stress. Mr. Parsons?
Thank you, my lord. Now, Mr. Elgar, just before we adjourned yesterday, you admitted that you had set fire to your premises. Do I understand you now wish to retract that admission?
Yes.
Very well. Well, I'd now like to ask you some questions concerning the paraffin can that was found in your shop premises. You may recall the testimony of Fire Officer Pettit of the Fulton Fire Brigade, who said he found a 5-gallon drum in the back room, which was empty, though it had clearly contained paraffin because of the smell from it. Now, you put that there, did you not?
Yes, I've already said that.
Yes, I know. You'll just bear with me for one moment. Was the can full or empty when you put it there?
It was full.
Now, how did you acquire it?
Right. bought it from the ironmonger's.
Yes. Am I right in saying you bought it from Squire's hardware store, Denman Street, Fulchester?
Yes.
Now, can you recall when you bought it?
Sometime in September.
Yes, to be exact, the 18th of September last. Would that be right?
I suppose so.
You suppose? Well, that's the date I have in a copy of the receipt here from Squire's hardware store. Would you dispute this?
No.
No. So on September the 18th, 4 days before the fire at your shop, you placed a large can of paraffin in the back room. Now, you've explained to the court that the reason for this was that in the winter you were going to heat that back room with a paraffin heater. You had not yet decided which model to buy.
That's right.
So, will you please tell the court, why did you buy all this paraffin to fill a heater you hadn't yet bought?
I just saw it in the ironmonger's and I bought it.
Well, I mean, would you buy petrol if you didn't have your van?
That's an absurd analogy.
Well, I'm sorry you find it absurd. I'll tell you what I find absurd, Mr. Elgar, what I find utterly preposterous, and that's a series of limp, implausible explanations you've given this court. I'll ask you one more question about the can, and perhaps this time you can summon up an answer that has a ring of truth about it. Station Officer Pettit said that when he found the can after the fire, the tap at the bottom was in a diagonal position. That is to say, it was neither fully closed nor fully open. Now, how do you account for that?
Well, I can't.
You can't. Or did you put the tap in that position when you left the can there?
No.
Well, how do you think it got like that?
The only thing I can think of is that in moving furniture around in that room, somehow something knocked against it and budged it a little.
Somehow something knocked against it and budged it a little. Well, that answer is just about as convincing as most of your other answers. Let me ask you something that requires a simple yes or no. Would you say that if someone wanted to start a fire somewhere, a very good way to do it would be to leave a large can of paraffin dripping slowly so that everything in the vicinity became soaked in paraffin?
Well, it'd be just as easy to pour all the paraffin straight out.
Yes, either way, very effective.
I imagine so.
You imagine?
I have no experience of starting fires.
Well, I now come to the evidence given by your friend and former partner, Gerald Stroud. You heard him testify that he visited you at the shop on September 19th last, 3 days before the fire, and found you upset and angry about a letter you had received from the landlords about the higher rent. Now, was Mr. Stroud correct in describing you as upset and angry?
Yes.
And am I right in saying that as a result of that letter, you made 2 phone calls to the landlords, Messrs. Chester and Hussey?
Yes.
And in fact, in the second phone call, you became quite abusive, did you not?
Not really abusive, no.
No? Mr. Stroud has testified that you told him you were going to refuse to sign the new lease, and that you said the shop can go up in flames for all I care. But you've denied this. You claim you said the shop can go to blazes for all I care.
That's right.
Go to blazes. Now, that's a rather old-fashioned phrase, isn't it? I wouldn't have thought it was still in common usage.
I simply meant the shop could go to hell.
Yes, or something much more inflammatory. But you are asking the court to believe that in a moment of anger, you would say, go to blazes. What you said was, the shop can go up in flames for all I care, and that is precisely what you meant. Because, in a fit of pique and anger with your landlords, you decided to set fire to the premises. You then went out and bought a 5-gallon can of paraffin. You then decided to cheat your insurance company by buying the most expensive antiques you could afford, concealing them in your van, and then adding them to the claim, along with everything else that had been destroyed or damaged in the fire. No further questions.
And you wish to re-examine, Mr. Lotterby?
Yes, briefly, my lord. Mr. Elgar, whereabouts is this ironmonger's, Squire's, where you bought the paraffin?
In Denman Street.
Is that far from your shop?
No, it's just round the corner.
Mm-hmm. Do they know you in there? I mean, do they recognise you know where your shop was?
Oh, yes.
Well, why didn't you go further afield to get your paraffin, to somewhere where you weren't known?
Why should I?
Exactly. Why should you? Thank you, Mr. Elgar.
Mr. Elgar, I wish to ask you a question.
Yes, my lord.
Which I think your counsel has neglected to do.
My lord?
You have testified that you kept a dozen or so blankets in the back room used for packing.
Yes.
Now, were those blankets in the same part of the room as the can of paraffin?
No, they were on the opposite side.
Members of the jury, you will remember that the fire officer, Mr. Pettit, testified that if the fire had started amongst the blankets, as opposed to amongst the wooden furniture, that it might have smouldered for several hours so long as the blankets were not close to the paraffin.
I'm deeply indebted to your lordship. Something I'd quite overlooked.
Yes, I rather thought it was, Mr. Lotterby. You may return to the dock.
I call Marion Elgar.
Marion Elgar, please.
What is your religion?
Church of England.
Take the Bible in your right hand and read aloud the words on the card.
I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth and nothing but the truth.
Your name is Marion Elgar, and you live at Briar Cottage, Haley Hill, Fulchester?
Yes.
And you are the mother of the defendant, Peter John?
Yes.
Mrs. Elgar, I understand that you've been brought here by ambulance from Fulchester Royal Infirmary and that it is waiting to take you back.
Yes.
You may be seated if you wish.
I'd rather stand.
I promise that we will keep you here for as short a time as possible.
Thank you.
Mrs. Elgar, how long have you lived at your present address?
Many years. My husband, my late husband, bought the cottage just after the war. It must be, 27 years.
And am I right in saying that it is only in the last 2 years that your son, the defendant, has shared the cottage with you?
Yes. He came to join me when my health began to deteriorate.
Now, Mrs. Elgar, will you please tell the court what you remember of the evening of September the 22nd last?
Was that the night of the fire?
Yes, it was.
Well, Peter came home from the shop about the usual time.
Now, what time was that?
Between 6 and 6:30. We had a drink, some sherry.
You always have a drink?
No, only on Friday and Saturdays, and that was a Saturday. It's a habit that dates from my husband's time. He would only have a drink on Friday and Saturday evenings. I think Peter does the same. It's strange how habits pass on to...
Mrs. Elgar, you were saying you had a sherry?
Yes. And then Peter went into the kitchen to make the dinner.
That's customary, is it?
Yes, he's an excellent cook and he enjoys it, which I don't. Afterwards, we watched television.
Now, what time would that be when you'd finished the meal and were sitting down watching the television?
Well, I can't be sure. About 8:15, I should think. Yes, it must have been, because it was about an hour later that we got the phone calls.
Ah, yes. Now, would you please tell the court about those telephone calls?
Well, there were two of them. The first was from the police telling Peter the shop was on fire. And the second was from one of the tenants in the flats above the shop, phoning from a public coal box to say the same.
And what happened then?
Well, Peter dashed out and drove off. I heard one strike and he hadn't come in. In the morning, I found him sitting in the kitchen with his face and hands still black from the fire.
Are you quite certain that from the time your son came home from the shop at about 6:30 until the time the telephone rang at 9:20, he was at home in the cottage with you and never left?
Quite certain. Yes.
Thank you, Mrs. Elgar.
Now, Mrs. Elgar, still on that same fateful evening, when your son went into the kitchen to prepare the meal, where were you?
In the sitting room.
Were you already watching television?
No, I don't think I watched television that evening before supper.
But you can't be sure.
Well, it's many months ago.
Yes, quite so, quite so. Now, how long would you say your son was in the kitchen preparing supper?
I really don't know. About half an hour or so.
Yes. Is there a back door in the kitchen?
Yes, it leads to the...
Yes, it leads to the garage at the side of the house, does it not?
Yes.
Now, suppose that you perhaps had been watching television and your son had gone out of that back door. Would you have heard him?
Yes.
You would have heard him go out?
I should have heard the door open and I'd have heard it close.
You're quite sure? Your hearing is good?
There's nothing wrong with my hearing.
But just suppose, Mrs. Elgar, suppose you had been watching television and your son had gone out of the back door, opening and closing it quietly.
What is it you're suggesting?
I'm suggesting that if the meal had been something that more or less cooked itself, if it could be left over a low light, your son, in that half hour or so, could have driven into Fulchester, to the shop, and been back in time to put the meal on the table.
No, he couldn't. I'd have heard him. I'd have heard him go and I'd heard him come back. You've no right to make such a wicked insinuation. No right at all. He's suffered enough already. I won't stay here and listen to your wicked insinuations.
Mrs. Elgar.
You can go to blazes for all I care.
Mrs. Elgar, how old are you? How old are you, Mrs. Elgar?
Please answer the question, Mrs. Elgar.
Oh, I'm sorry, I didn't hear. I didn't hear what was asked.
Thank you, Mrs. Elgar. No further questions, my lord.
But
That's all right, Mrs. Elgar. You may leave now unless Mr. Lotterby has some more questions for you. Thank you for coming from the hospital.
I call Louise Anstruther.
Louise Anstruther, please.
You really are playing for sympathy, aren't you?
My lord, with your permission, Mrs. Anstruther will give her testimony from the wheelchair.
Very well, she may do so.
I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Your name is Louise Anstruther?
Yes.
And you live with your husband at flat 4, 17A, Manning Street, Fulchester?
Yes.
Now, that is the flat above the antique shop, Elgar and Stroud, is it not?
That's right, except the shop's there no more. Sign's been taken down.
The premises are still closed, are they?
Yes, Your Honour. Or should I say, my lord?
As long as the tone is respectful, Mrs. Anstruther, I never mind what the witness calls me.
Mrs. Anstruther, how well do you know the defendant?
Oh, fairly well. Saw quite a bit of him the 2 years since we moved in the flat.
Where was this? Where did you see him?
At the shop. I used to pop in there quite often.
You're interested in antique furniture, are you?
Oh, I'd like to be. Mr. Elgar taught me quite a few things about different periods and different woods and about what to look for to tell if something had been doctored up to look like an antique.
Did you ever buy anything from him?
Yes, 2 chairs. Oh, not proper antiques. Country pieces, Mr. Elgar called them. Windsor chairs.
When did you last call in to see Mr. Elgar?
Earlier on the day of the fire in the afternoon.
Now, did you go into the back room or did you just stay in the front part of the shop?
No, I went into the back room. Mr. Elgar was working there.
Now, can you remember what was in that room?
Yes. I remember seeing a big can in the corner, some bits of furniture, and there was a pile of blankets he used for packing on the floor.
A pile of blankets? Now, whereabouts in the room? Near the can you've told us about?
No, away from there on the other side of the room.
Thank you, Mrs. Anstruther, that's all.
Mrs. Anstruther, from what you've been saying, I infer that prior to the fire you were not confined to a wheelchair.
Yes, Your Honour.
Are you the person who was injured on the night of the fire?
Yes.
Tell us about the fire.
Well, there was a banging at our front door, and I went to it, and it was Mr. Peters from the top floor. He said that the shop downstairs was on fire and I'd better get out.
Yes, can you remember what time this was?
Oh, about 9:15, or perhaps 10:02. Well, I looked down the stairs and I couldn't see any fire or smoke or anything, so I nipped back in the flat to get our bits and pieces.
To get your...
Oh, I've got a few bits of jewellery, and Fred, my husband, has some silver cups that he won as a lad. He was a fast runner, a sprinter, the 100 and the 220.
Yes, I gather then that your husband was not at home that evening.
No, he was at the pub, Your Honour. It being Saturday, I didn't expect
So
him
you
to
went
close
back
them.
to collect your valuables?
Yes, and put them in a suitcase together with my fur. Then I went to the front door, opened it, and got the shock of my life. The lights had gone out on the landing, and all I could see was smoke. Great gusts of smoke coming up the staircase like clouds, and I could smell it. Oh, I didn't dare go any further. I turned and went back as quick as I could, dropping the suitcase. By now, the flat was full of smoke. Well, I went to the window, opened it, and leaned out. It was very bright down in the street. Lots of lights all over the place. And I could see faces and the fire engines, and I could hear the siren. There was a lot of noise and people shouting. And I shouted down, "Help! Help!" And I could see faces looking up. And I yelled, "Should I jump?" And I thought I heard a man say, "Right you are." And I could see men standing below the window, sort of holding their arms out. And I put one foot up on the ledge and I pushed myself out. But I found out later that what the man was yelling was, "Stay right where you are." Oh, I was in hospital for 4 months.
And now you are paralyzed from the waist down?
No, not strictly speaking. My functions, they still function, I'm thankful to say. It's just my legs. It's just the use of my legs.
I see. Thank you. Mr. Parsons?
Thank you, my lord. Now, you know, don't you, Mrs. Anstruther, that Mr. Elgar is accused of having started the fire which resulted in you being paralyzed.
Of course.
So I take it you don't blame the defendant for the injuries you incurred.
No, I don't.
Now, why not?
Why not? Because he never set fire to the shop.
Well, what makes you say that?
Well, he couldn't. Not on your life he couldn't. It's not in his nature.
Not in his nature? Now, what do you mean by that?
Well, some men are capable of doing something violent like that, and some aren't. And he couldn't. He's a very gentle man. Oh, couldn't swat a fly, I'm sure. And as for setting fire to antiques...
Yes, so you think that poor Mr. Elgar has been wrongly accused and you've come here to help him?
Yes, I do.
That's why you've come to tell the court about the blankets.
Well, it's important, isn't it?
Yes, but did you really see them?
Yes, I did.
Now, Mrs. Anstruther, when you heard that Mr. Elgar had pleaded guilty to a charge of attempting to obtain money by deception, the deception being a fraudulent insurance claim on the damage caused by the fire, were you surprised?
Oh, yes, absolutely flabbergasted we all were.
Why was that? Was it because you didn't think it was in his nature to do such a thing?
Yes, and it seemed...
Thank you, Mrs. Anstruther. No further questions, my lord.
No, my lord.
Thank you, Mrs. Anstruther. You may leave the Whitney. That is to say, you are free to leave the court. You may either go, or if you wish to stay for the rest of the proceedings, we'll find a place for your wheelchair over there.
I'd like to stay, please.
Very well.
That concludes the case for the defence, my lord.
Members of the jury, you have listened carefully to all the evidence, and you have been addressed by both counsel. Now, there are 2 charges against the defendant, and they are, 1, that on the 22nd of September 1973, without lawful excuse, he damaged by fire a shop at 17 Manning Street, Fulchester, belonging to Chester and Hussey, intending to damage such property. And 2, that on the 22nd of September 1973, without lawful excuse, he damaged premises at 17 Manning Street, Fulchester, being reckless as to whether the lives of the tenants at 17A Manning Street, Fulchester, would be thereby endangered. Now, the key question you have to consider is how was that fire started? Now, you've read the report of the fire prevention officer, which stated that no accidental cause could be found for the fire, and therefore it must be considered to be of doubtful origin. Now, was that fire started quickly, with the aid of paraffin, late in the evening, when only the defendant had access to the premises, or had it been smouldering there for several hours? Now, you will know that the defendant has already pleaded guilty to another offence. And as counsel has pointed out, that does not necessarily presuppose that he is guilty of the offences with which he is now charged. As always, in a court of law, there must be a presumption of innocence. Each charge must be considered on its own merits, and the accused person must be considered innocent until he is proved guilty. However, you may think that by admitting that he is guilty of that other offence, he has provided himself with a motive for committing the offences with which he is now charged. And you might also think that had it not been for the resourceful inquiries made by the insurance company investigator, Miss Green, the defendant might not have been charged with either offence. It will not have escaped your notice, members of the jury, that there is no direct evidence against the accused. That is to say, nobody saw him strike a match in order to start the fire. What evidence there is against him is circumstantial evidence. Now, a piece of circumstantial evidence does not of itself prove a person guilty, but it does create a circumstance, or circumstances, which makes it possible for that person to be guilty, or alternatively makes it less likely that any other person is guilty. Where the weight of circumstantial evidence is overwhelming, it is sufficient to convict, but only if the prosecution has proved to you, beyond all reasonable doubt, members of the jury, that the accused is guilty. Will you now please retire to consider your verdict?
Members of the jury, will your foreman please stand? Just answer this question, yes or no. Have you reached verdicts on which you're all agreed?
Yes.
On the first count, do you find the accused, Peter Elgar, guilty or not guilty of damaging by fire the premises of a shop at 17 Manning Street, Fulchester?
Not guilty.
On the second count, of damaging the said premises, being reckless as to whether the lives of the tenants at 17A Manning Street, Fulchester would be thereby endangered, do you find the accused, Peter Elgar, guilty or not guilty?
Not guilty.
You are discharged and are free to leave the court.
All stand.
Next week, a chance for you to join another jury in assessing the facts when our cameras return to watch a leading case in the Crown Court.